So when it happens and when it goes wrong, or when you're thinking about putting this in place, what we encourage you to do is to think about it from the worst case scenario. And there are, as you'll be hearing on the social media through the different areas where it's happening, the use of restraint with certain services is now, it's got such a high profile. And again, I think in terms of prevention and management of violence, the techniques that staff, particularly in health, use are mindful of that particular issue, that at some point, if restraint goes wrong, it could be considered a criminal action. The issue that could happen for anyone that is found to be in a way using excessive force to undertake a restraint at that point in time, who's not thinking about it through, or there isn't the evidence to support the justification of why restraint would be used, could be seen through a legal route, or could be taken through a legal route. It's very rare, but it can happen. And civil actions, while not necessarily at the risk of the individual so much, but certainly more at the employer, albeit the individual may still be called through if there is a prosecution being pursued. At that point, it's that consideration of what was the justification for it. And there's a lower bar for civil actions being taken forward than there are for criminal actions. Still rare, still something that we've not seen a great deal of in health and social care settings. But with a human rights bill that's coming through, and people understanding their rights far more, and mental health standards and scrutiny and inspection on the landscape regularly, these are things that have to be considered by care staff that are in this situation. And it should be, anything that we're doing is guided from a rights-based framework. And Scotland's about to bring forward its own and updated version of the human rights. But if you start thinking about the European Court, the the rights of people with physical disabilities, all of those are integral in terms of the legislative duties that we use regularly at the Commission under the Mental Health Care and Treatment Act and under Adults with Incapacity Act. So restraint has been defined within those legislative frameworks, but only within the context that you continue to look about you continue to consider the principles, the articles in terms of people's right to life, right to family life, to being treated, not to be treated inhumanely, and the prevention of torture. So there's always those factors that one should be considering when you're in an environment or you're working with an individual where restraint has been something that's been used in the past or maybe being considered. So almost like your aid memoir, it's this idea of when you're in it's a challenge, there's no getting away from it, a challenge in a busy adult acute setting, or in a learning disability service, or in a care home where you've got individuals whose stress and distress behaviours are causing concern to the staff, and the staff are at risk. That's absolutely understandable. But it's that thing of always working through step by step what we would do in this place if we are about to, or we're considering where restraint might come in the steps that we provide care in. And from the Commission's perspective, involvement at the get-go with the individual, with their family, with the proxy decision makers if there's somebody there, with managers, with any of the care staff, the involvement as broadly as you possibly can through the multi-professional team is absolutely to be considered at the get-go. We also we look for where consideration of alternatives to restraint have been put in. If I go back to the locked door policy, one of the things that we advocate for is using different types of doors, keypads, people having access to it, having clarity at the wall saying, here's what it is. The two-way doors are different handles. So there are always alternatives. The same for ensuring that someone doesn't have to be restrained with direct hands-on. Maybe, as I've said, finding different environmental snoozling rooms, positive behavioural support, increasing access to psychological interventions or therapeutic interventions are all effective ways of looking at alternative restraint. we look for when we're evaluating, as with managers when they're evaluating, as we would recommend managers do, is what is the minimal what is the minimum use, and when does that move to being unacceptable? We see more increasingly, and Denise will talk a little bit about it in terms of the seclusion policy, this should be used in the same way in terms of a policy that talks about if restraint is required in the environment. And that should be done for the minimum amount of time and the minimum standards by staff that are trained and knowledgeable in this. And it should be audited and it should be monitored. And that all fits around about the requirements of the organisation. And it flicks back to what I was saying about if there's a case, if there's a challenge, if people take a legal route to it, if the organisation has these in place, i.e. the policy's clear, it's definitive, it's regularly reviewed, the environment has opportunities to do anything other than put a restraint in place, and staff are knowledgeable about alternatives to it, then all of those should guide what would happen differently and protect individuals and the care staff when restraint is required. The last bit for me here is around about using the legislation. The legislation is set up, AWI and Mental Health Act, the principles are there, they intertwine in a lot of ways, but there is the authority to use restraint as a last resort. And knowing that and being clear about that and having discussions is the useful thing. We find when we go out that it may not be very well versed for staff to know the principle of proportionality and where that's used. That conversation might not have had it. We find regularly that care plans are not descriptive enough or definitive enough. Debriefs don't take place when they should do in terms of what's happened. Care plans are not then updated. There's no evaluations. All of those things are inherent in what we would expect in place of the law. The more concerning one that we usually pick up is around about AWI, where people aren't necessarily clear on their roles as a delegate, as somebody that's been delegated with a specific power. So knowing that, understanding that, and being aware of that is part and parcel of ensuring that rights are given, or people's rights are highlighted and they're made aware of them. We do have a duty to care. We have all of us have professional requirements, responsibilities that ensure that we must consider what happens to that individual that we're looking after. It can't be harmful, it can't be neglectful, because at that point it takes us back into a different route of what happens to that individual should things go awry. The initial assessment that we expect to see when this has happened should at least then have some sort of evidence of further and wider discussion, inclusive of what's happened to that person, and where possible, if they've got carers or relatives that are involved. But it should have all the team in it, and it should be continuous. It should cover physicality of the person, it should cover their background, it could be as broad. The guidance clearly sets out what this is. And one of the areas that probably works very well, but it's probably underused, is around positive risk taking. So it's that idea of people's recovery improves when you consider doing positive risk. But if all we're using is the standardised risk formats and looking at restraint as being something that we can use rather than as the last option, then it takes us away from considering, could we be thinking about this differently? And the very last one is around about monitoring the use of restraint. What we're seeing more often now are better policies. Scottish Patient Safety Programme has been incredibly useful as a way of ensuring that practices such as restraint or the use of different types of medication are all being better monitored to the service and reported upon. I think there's still a bit of a catch in terms of the reporting and the wider understanding of that, but it is that essential part of ensuring that when you get better at having a service, it's because you've been monitoring. And I think that might be me from the last slide.